Hello everyone, greetings of the day. This is Komal Mathur, a legal intern at LEXIS and Company and a law student at Manipal University, Jaipur. I am glad to have this opportunity to intern with LEXIS and Company, and which is why I am present in front of you all. So the topic or purpose of today's video is Doctrine of Frustration under the Indian Contract Act. Let us start our topic with a brief introduction. What is frustration? Frustration in a general scenario means defeated, and this term has been widely used in agreements and contracts between the parties. The term frustration is being used to deal with unsuccessful transactions which could not be completed due to any reason. In law of contracts, doctrine of frustration has emerged as one of the most common issues which have a right to deal with failed contracts. Now, what exactly the doctrine of frustration is? As a general rule, parties to contract are having an intention towards the fulfillment of their part, and in case of breach, parties breaching is liable to compensate for the same. But an expression to this rule is laid down in Section 56 of Indian Contract Act 1872. Section 56 deals with the doctrine of frustration as being acts which cannot be performed. Under this doctrine, a promisor is relieved to any liability under a contract in the event of breach of contract, and contract will be deemed to be void. Now, Section 56 is based on the maxim "res non cogit and impossibilia", which means the law will not compel a man to do what he cannot possibly perform. The basis of the doctrine of frustration was explained by Supreme Court in the case of Satyabrata Bose versus Munigrim, in which Justice Mukherjee held that the basic idea upon which the doctrine of frustration is based is that of the impossibility of performance of the contract, and the expression frustration and impossibility can also be used as synonyms. Now, the doctrine of frustration is applicable only in two cases. Now, what are those cases? The first is if the object of contract has become impossible to perform. Second possibility is an event has occurred making the performance of the contract to be impossible beyond the control of promisor. Now let us understand these conditions with the illustration. As a resident, A entered into a contract with B. A is the resident of India and B is resident of China, and they entered into a contract for the export of 550 heavy trucks. Initially 100 trucks were delivered. Later, a war was announced between India and China, and the government of India suspended all the business transactions with China. Now, after this contract has become void. Now, one more illustration if you want. See, if C has made a contract with D and due to some reason C died. Now, C is unable to perform the contract and he or she has no successor. So, what will happen in this case? The contract becomes void, and the doctrine of frustration is being applied here. Now generally, doctrine of frustration can be applied in following cases. The first is death or incapacity of a party, which I just told you in my second illustration. Where a party to contract has died after entering into a contract, or the party is incapable of performing the contract, in such a situation the contract will deem to be void. So for the example, I would like to cite a case which is Robinson versus Davidson. Second condition is frustration by virtue of legislation, where a law promulgated after the contract is made and makes the performance of the agreement impossible, and thereby the agreement becomes void, as happened in the case of Rozan Mian versus Tahira Begum. The third condition is frustration due to the change of circumstances. This particular situation deals with those cases where there is no physical impossibility of performance of the contract, as it happened in my first illustration of the export of the trucks. But because of the change in circumstances, the main purpose for which the contract was entered into was defeated. Now, there comes two kind of impossibilities in this kind of doctrine of frustration. So what are those two kinds of impossibility? First is the initial impossibility, second is subsequent impossibility. What is initial impossibility? The object of making any contract is that the parties to contract would perform their respective promises, and where the contract is itself impossible to perform, the parties would never enter into it. Initial impossibility deals with those cases where the contract was impossible to perform from the very beginning, that is from ab initio. For example, if a married man, knowing that he cannot marry again and promise to marry to any another girl, then he is bound to compensate the party because he made a fake promise and it was not a contract at all. Now the subsequent impossibility, it deals with the cases where the contract was possible to perform when it was entered into, which means the contract was possible ab initio, but because of some event the performance has become impossible or unlawful and therefore it discharges the party from performing it. For example, if A purchased tickets from B for watching a cricket match and he pays 50% as an advance. Now, if the match is cancelled, then A cannot recover from B as the cancellation of match was beyond the control of A and B both. So that's it for today. Thank you. Have a nice day.